Early this morning at exactly 6:42 a.m. Eastern Time, United States Marshals arrived at Mar-a-Lago carrying a federal arrest warrant signed by a magistrate judge the night before. The operation was calm, controlled, and procedural. There was no public confrontation, no resistance, no spectacle. The warrant was served, the defendant was placed in handcuffs without incident, and he was transported in a federal vehicle to the Miami Federal Courthouse holding facility for processing. At nearly the same moment, approximately 300 meters away in West Palm Beach, Melania Trump entered a federal courthouse under a formal cooperation agreement. As he was being taken into custody, she was being sworn in before a federal grand jury. That timing was not coincidence. It was deliberate prosecutorial strategy. 6 days earlier, the United States Supreme Court denied the defendant's final appeal. Within hours of that denial, Melania's cooperation agreement was formally filed. Prosecutors then coordinated the execution of the arrest warrant to ensure she was physically inside the grand jury room, under oath, before he was detained. Once she began testifying, he had no ability to contact her, influence her, or interfere with her testimony in any way. That level of synchronization reflects intentional legal planning at the highest level. Here is how the first 6 hours unfolded with precision. Shortly after 6:30 a.m., Melania's legal team arrived at the West Palm Beach Federal Courthouse. They met with federal prosecutors to review the final terms of her immunity agreement. The agreement required complete and truthful testimony in exchange for pleading guilty to one count with a recommendation of probation. She signed formal acknowledgement of those terms. Prosecutors then notified the U.S. Marshals Service that she was present and prepared to testify. At 6:42 a.m., Marshals arrived at Mar-a-Lago with the signed arrest warrant. Secret Service personnel coordinated access. By 6:47 a.m., the warrant was served. The defendant was taken into custody, handcuffed, and informed of the charges. His attorneys were notified and began traveling to Miami. By 7:15 a.m., he was transported to the Miami Federal Holding Facility, where he was processed, photographed, and fingerprinted. Meanwhile, less than a quarter mile away, his spouse was preparing to testify against him. At 8 a.m., Melania entered the grand jury room and began sworn testimony. At that moment, he was already in federal custody. He could not communicate with her directly or indirectly. The timing eliminated any opportunity for interference. At 9:30 a.m., the grand jury recessed while prosecutors evaluated the testimony presented so far and discussed whether the evidence supported additional charges beyond the original indictment. At 10:45 a.m., the grand jury reconvened. Her testimony resumed, focusing specifically on financial documents, property valuations, loan applications, and audio recordings she had provided to federal investigators. By noon, after 4 hours of sworn testimony, the grand jury began deliberations on a superseding indictment. They deliberated for approximately 1 hour before voting unanimously to approve 12 additional federal charges. The defendant now faces a total of 46 counts. His arraignment is scheduled for 1 p.m., where he will appear before a magistrate judge to enter a plea and address conditions of release. The original indictment earlier this year included 34 counts related to falsified business records and bank fraud. The superseding indictment adds 12 new counts, including 6 counts of conspiracy to commit bank fraud under Title 18 U.S.C. Paragraph 349, 4 counts of wire fraud under Title 18 U.S.C. Paragraph 343, 2 counts of making false statements to financial institutions under Title 18 U.S.C. Paragraph 1014. A superseding indictment does not replace prior charges. It adds to them when new evidence emerges. In this case, the new evidence came directly from Melania's testimony and materials she provided. Conspiracy charges require proof that 2 or more individuals agreed to commit fraud and took steps to carry it out. Prosecutors allege that loan applications listed inflated property valuations and that electronic communications were used to transmit those documents to financial institutions. Each qualifying transmission may constitute a separate wire fraud count. Each allegedly false loan application may constitute a separate false statement charge. If convicted, each conspiracy count carries a potential maximum sentence of up to 30 years. Each wire fraud count carries up to 20 years. Each false statement count may carry up to 30 years. While federal sentencing guidelines often result in concurrent sentences, the theoretical exposure spans decades. According to prosecutors, Melania presented 3 key categories of evidence. First, an audio recording of a 2020 phone call involving discussions about property valuations submitted to a financial institution. Prosecutors argue the recording reflects awareness of differing appraisals and intent regarding which valuation would be submitted. Second, text message exchanges discussing how property values were reported for banking versus tax purposes. Prosecutors characterize these messages as evidence of knowledge and intent. Third, handwritten notes from a 2019 meeting with accountants that allegedly referenced preparation of differing financial statements for separate purposes. Spousal testimony can be significant because it may include private conversations and direct observations. However, defense attorneys will likely challenge credibility, arguing that cooperation agreements create incentive to testify favorably for prosecutors. In this case, prosecutors emphasize that her testimony is supported by documentary and audio evidence. Her cooperation agreement reportedly offers reduced exposure in exchange for full and truthful testimony. Such agreements are common in federal prosecutions when a witness faces potential liability but agrees to assist investigators. If she fails to testify truthfully, the agreement may be revoked. Her decision to cooperate significantly alters trial dynamics. Prosecutors now have insider testimony, plus recordings and documents. Defense attorneys will likely argue that financial reporting involved reliance on accountants and professionals, and they will contest the interpretation of the materials presented. At today's arraignment, the magistrate judge will formally read the charges. The defendant is expected to plead not guilty. The court will then address bail conditions. Prosecutors may argue he presents flight risk due to international assets and access to private travel. Defense counsel will argue for release under reasonable conditions. The judge may consider passport surrender, travel restrictions, or electronic monitoring. Because a superseding indictment has been filed, the speedy trial timeline resets. Trial preparation could take 6 to 8 months or longer, allowing for discovery review, evidentiary motions, and potential plea negotiations. Historically, cooperation by close associates reshapes high-profile federal cases. Whether viewed as betrayal or self-preservation, its legal significance lies in whether the evidence proves guilt beyond a reasonable doubt. That determination will ultimately be made in court. This morning's events followed procedural federal protocol. A cooperation agreement executed, a grand jury convened, a superseding indictment returned, a lawful warrant served, and an arraignment scheduled. The legal process is now moving forward through formal judicial channels, where evidence, not speculation, will determine the outcome.